Alright, so Mr. Austin, have you gotten to look at your PSI?
Yeah.
Alright, 7 seconds. Okay. So we got it. This is in the matter of the state of Michigan versus Trevor Austin, file number 2022-20788 FH. You can go up there and stand by Mr. Daly. This is the date time set for sentencing on a violation of probation. So, Mr. Austin, have you had an opportunity to read and review the probation violation report?
Yes.
Right? Have you had an opportunity to review that report with your attorney?
Yes.
Are you satisfied with Mr. Daly as your attorney and the advice that he's given you?
Yes, ma'am.
Okay. Mr. Daly, do you wish to explain or challenge the accuracy or relevancy of any information in the probation violation report?
Right.
All right. Before the court passes sentence, is there anything you'd like to say on behalf of Mr. Austin?
Yes, Your Honor. Before Mr. Austin gave up sobriety, he had 6 months of sobriety. He was doing very well. He was working every day, and he got hooked back up with meth again. He understands that he has no life when he's using drugs, and he truly and sincerely believes that. But for whatever reason, after so long in the past, he's gotten out there and gotten hooked up again and repeated that behavior. He doesn't want to do that. And the big thing is that he went 6 months clean and sober. That means he had to be tried, Judge. He couldn't do that without trying. Was he successful? No, but at least he was trying to be. I think you have somebody that has reached the point where they know what they've done with their life and wants to do the right thing, but he hasn't quite got it figured out yet.
Mr. Austin, anything you want to say on your own behalf?
That I'm sorry to the courts. Sorry to myself that I'm back here. Myself and my kids. I want to do the right thing. I really do. I want to get back to normal life. I was married for 10 years before all this, and it's been a long journey of hell, and I'm ready to buckle back down, let all the old people go that keep getting me back into the situation.
Have you ever been to inpatient treatment or?
Yeah, a couple times.
So, Mr. Austin, like you said, you were married before you got into this, you had a normal life.
Yeah,
And
I did too.
everything.
I lost everything because heroin and meth.
You know, and if you're struggling, you know, Mr. Moore is your probation officer, right? Yes. I mean, if you go to him and you say, I need extra help, he can point you in the direction of treatment programs.
Yeah.
You know, whatever it is that you feel that you need, and, you know, he wouldn't violate you for asking.
Yeah, he seems like a good guy.
Is a good guy. All right, well, Mr. Austin, it is the sentence of the court that you will be reinstated to probation. You'll serve 15 days in Lenawee County Jail, credit for 15 days served. Tuesday morning, I need you to report at 9 a.m. with an address from Mr. Moore where you're gonna stay.
Okay.
I know there's some different shelters, you know, different places you can reach out to.
Shelter in Jackson.
Are you from Jackson?
Yeah.
Okay. And
Okay.
you do have the right to appeal this sentence, so my bailiff's going to hand down to you your notice of right to appellate review. Just sign one copy for our records, just to acknowledge you received the paperwork. The other copies are for you. If you wish to appeal your sentence, you would fill the information out on the form. He can't, it's easier for him to sign on the TV thing,
Yeah.
isn't it? Or is he?
So this will work.
Okay, you're tall, I forgot.
Yeah,
Sometimes people aren't tall enough to do that.
right here. It is 17. Oh, 23. Thank you.
So be safe this weekend.
Yep. So that'll be, how we get now.
Today, unless there's something else holding you.
I think I still owe a little time in Hillsdale.
Do they have a holder on you?
I don't think so.
Okay, well, I mean, Mr. Moore will know if you have a holder and you go somewhere else, but, like I said, Tuesday morning or the first day you're out, you need to report to Mr. Moore,
Okay.
okay?
Yep.
All right, good
And
luck to you, sir.
Mr. Austin, you have my phone number, correct?
Yes, I do.
Okay.
Actually, can I write it down on this paper right here? Just in case I don't
Yes.
have it.
Yes.
And it is, wait 1 second.
It's gonna be 517-260-848.
Hold on, Mr. Moore, can
I
you
was
go a little
writing down-
slower?
What is it again?
260-8480.
260. All right.
And if you get, for some reason, dropped off in another county or stranded, do you make sure that you call me?
I will, I definitely will.
Okay.
Thank you.
All right, good luck.
All
We
right.
keep this weekend.
Yep.
All right. Miss Adams, could someone reach out to Miss Hennigan?
Okay,
So I'd like to take care of her client while I have,
Thank you, ma'am.
not have the interpreter wait too long. All right. Mr. Daly, thank you.
Thank you, Judge. I'm back on.
Mr. Malaro,
Yes,
who you have?
Jeffrey Elliott,
All right,
we are ready.
all right, I'm ready to. Okay, so,
No, stand.
this is Mr. Daly, you and your gentleman step out in the hall. All right, this is in the matter of the state of Michigan versus Jeffrey Allen Elliott. We have two files, file number 23-21200FH. I have Salvatore Malaro appearing on behalf of Mr. Elliott on that file. Your P number, Mr. Malaro.
P42566, Your Honor.
And then I have Mark Berkey from the Michigan Department of Attorney General. Sir, what is your P number, please?
Your Honor, good morning. My P number is 54935.
And I mispronounce your last name again. Did I mispronounce it?
Your Honor, actually, well, it's historically pronounced Burke, but I have gotten Berkey all my entire life. So I go by either one.
All right, well, I'll go with what you like, Burke. All right, so, and then on file number 21-20212FH, I have Salvatore Malaro again appearing on behalf of Mr. Elliott. And that case is with the Lenawee County Prosecutor's Office, and we do not have a prosecutor present. So this is the date and time set for sentencing in this matter. Mr. Malaro, you received a copy of the pre-sentence report.
We did, Your Honor.
All right, and Mr. Malaro, have you had an opportunity to review that with Mr. Elliott?
We have.
All right, and Mr. Burke, did you receive a copy?
I do. I have a copy. Yes, Judge.
Excellent, all right, very good. So, Mr. Elliott, have you had an opportunity to read and review the pre-sentence report?
I did.
Okay, have you had an opportunity to discuss the pre-sentence report with Mr. Malaro?
I did as well.
All right, are you satisfied with Mr. Malaro as your attorney and the advice that he has given you?
Yes, ma'am.
Okay, Mr. Malaro, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
I would, Judge. With respect to personal history, Mr. Elliott is employed. He works at Atherton Mold Riga. I actually spoke to his employer.
And
Prior
that's
to
on
that.
page
Page
7,
Page 1 and
page 7. I have
page
that.
7 as well.
Fender states he is currently employed in Riga, Michigan, making bolts. Is that where you're working at? What's the name of that company?
I'm not really sure of what his company is called. I think it's Atherton Metro Molds or Atherton something molds.
Okay, so Mr. Malaro, you were able to verify his employment, but Mr. Moore is not yet, but I'm sure or Mr. Jones is not, but he will as part of probation.
Yes, I did speak to Mr. Atherton, Your Honor,
Okay,
at the last hearing, and he did inform me that he was employed there.
okay, excellent.
The other issue, Judge, is it's not more of a correction as to an explanation. Mr. Jones references that he wasn't able to contact Mr. Elliott for a period of time. Mr. Elliott was in custody for 47 days. It took him a few weeks to get his phone back on. If the court recalls, he had to post a $500 bond and then get back to work. So that was the cause for the delay in contacting probation. Other than that, we have no other issues with the report.
Okay. All right. So on file number 21-20212FH, the court or the probation department has computed the minimum sentencing guidelines to be 5 to 23 months. Do you agree with the computation of guidelines on that?
We do, Your Honor.
And then on file number 23-21200FH, the probation department has computed the minimum sentencing guideline to be 2 to 17 months. Do you agree with that computation of guidelines?
We do.
All right. Before the court passes sentence, starting with Mr. Burke, on behalf of the Attorney General, is there anything you wish to say on file number 23-21200FH?
I do, Your Honor. Yes, thank you. First of all, it looks like the guidelines, I'm looking at the range, it looks like 5 to 23. Is that not correct?
On that file, I have, no, I have 2 to 17.
You might be looking at the other case, Judge.
I have 2 sets of guidelines attached to the
Oh.
pre-sentence report.
You know what? That's okay. I've got it. Yep. I apologize, Your Honor. I didn't see the second page of that. Okay. Okay. So that being said, it's important, I guess, for the court to note that the defendant's arrears in this case is $65,650.60, and that's as of yesterday. The defendant has a current support obligation of $412 a month. The last payment that was made was almost 4 years ago. It was June of 2019, when the defendant took a plea on February 1st. He indicated that he could pay $500 that day, and he had proof of a job, and he would start making payments. And my MISIS report, Michigan Child Support Enforcement System Network report, that's dated yesterday's date, shows no payments at all. So since June of 2019. So I appreciate the probation department's recommendation of, what is it, 3 years of probation, and I'm fine with that. But I mean, if the defendant's not going to pay, I'd ask for a term of incarceration.
All right, thank you. All right.
Thank you.
Mr. Jones, were you able to verify employment?
I did not verify any employment, Judge. At the interview, I asked for stuff to be brought in, but nothing was provided to me. So I have a little concern that we don't even know the name of the business of where he's working. Maybe he is working, but I'm not sure how he's getting paid.
Mr. Malaro said it was Atherton.
Yes.
You got the website, didn't you?
Yeah, so Judge,
Could you spell it?
ATHERTON. So it's in Riga. It's right on 223.
And you get a paycheck? Do they take taxes out of your paycheck?
No. You know, he pays me $12 an hour cash. He's just a small shop.
So Judge, that would be why verification would be difficult. We got no tracking on it.
Okay.
I mean, I know where I live in Blissfield, so I know where it is. I know what he's talking about, and there is a business there. I didn't go knock on the door, but there is business there. There's actually several in the buildings.
Okay, all right. Mr. Milaro, anything you want to say on behalf of your client?
I would, Your Honor, this, Mr. Elliott was a requirement to be released, posted to $500. Why it's not showing on the AG's records, I don't know. Mr. Elliott posted to 500 when he was released. He was in February. I think he got out in February.
Yeah.
And then he today posted 250. I have the receipt. He says he can pay the.
You pay that downstairs directly.
Yes. He can pay the other jail and stuff, the 500. I think the court had required him to pay 500 by the end of the month. So that would make him current as what the court had directed.
I can pay it next week.
Well, he can pay it by the end of the month,
Yeah.
which I think
Next week.
is the terms of the
Okay.
how child support works. That's what's sufficient. So, and I can show the court the receipt if they want. Okay. Judge, he starts another job on Monday. It's called
Metro Landscaping.
Okay, so hold on a second. So let Mr. Milaro speak and then you'll get to speak.
I'm not
Okay?
nervous.
But otherwise, we're back and forth and my court reporter has to be able to make a permanent record and she has to denote who's speaking.
I don't know her, so she might throw stuff at me.
She might.
It's called Metro Landscaping. He says he starts that on Monday. So Judge, as we discussed when you agreed to release him, he does not guideline to a prison sentence. I know the recommendation is for a jail sentence on the 212FH file. I'd ask the court to consider putting that in the first status, so long as he's current in his support obligation. The underlying support obligation, I think this is a CSD transfer out of Alabama. As I often see when I did these cases, people leave state and it just gets out of control. But Mr. Elliott understands that this is a serious matter. He's serious about taking care of it. And so I'd ask the court to follow the recommendation with the exception of the jail sentence and impose that as a deferred sentence. So then make that a condition of both cases, as long as he stays current in his support obligation, he wouldn't have to serve that. He's a lifelong resident of the community. He had, I think as court knows, he's nervous, and when people are nervous, they make bad decisions. And I think that's part of what happened here. But I know he's remorseful for everything that has occurred, and he's intent on making it right, getting things done, and proving to the court that he can be productive. I mean, he's 41 years old. He does not want to spend his time in jail or prison in any matter, let alone these. And so we'd ask the court to follow the recommendation with the exception of the jail sentence and make that a deferred. Thank you.
All right, so Mr. Elliott, anything you want to say on your own behalf?
No, that's pretty much about it right there. The job I'm starting on Monday is a seasonal job. I worked it last summer too. So it's not actual new job, but it's a seasonal job that we're just starting Monday. And that one pays $20 an hour, so that's a little bit better than the 12. I can pay some more on my child support with that. But it's only seasonal, like I said. And after the season, I'll probably go back to Atherton's.
Mr. Burke, what was your P number again?
Your Honor, it's 54935.
Okay. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, potential for reformation, vindication for law, and the protection of society. So, Mr. Elliott, you're supposed to pay $412 a month in child support?
I believe that's the obligation.
Okay, is that correct, Mr. Burke, from your notes?
That is correct, Your Honor, yes.
All right, so Mr. Elliott, you do have proof of a payment here today, and then the bond that you posted. You are employed, so I'm much more interested in receiving child support than putting you in jail, which just costs us more money for the county anyway. So it's going to be the sentence of the court that on file number 2021-20212FH would be placed on probation for a period of 3 years. You're to pay $750 in court costs, $130 crime victim rights fee, $68 in state costs, $60 DNA fee. There's a $30 per month supervision fee. But if you were required to wear a tether, it would be $60 per month. I'm going to order that you serve 180 days in jail with 47 days of credit, but I'm going to defer that balance upon any violation. So if you don't make a child support payment, violate probation in any other way, then understand you will serve that balance. On file number, and there's to be no, is there no contact as well, Mr. Jones? Just with the victim?
That's correct.
All right, so there will be no contact with the victim in that case as well. Do you understand that?
Yes, sir.
On file number 2023-21200FH, will be placed on probation for a period of 3 years. We'll pay a $130 crime victim rights fee, $68 in state costs. We'll serve 47 days in Lenawee County Jail with credit for 47 days already served. You're to comply with all orders from front of the court, and you are required to make a payment of $500 each month to the front of the court. So that'll be $412 applied to your monthly obligation, and then the rest to the arrearage, which your arrearage is excessively high. You are to surrender all income tax returns to front of the court if there is not already an intercept on them, which I'm assuming you have. But you're not to consume any controlled substances, illegal controlled substances. You said you don't drink anyway, right? Not to consume alcohol. You're to submit to all testing through the Michigan Department of Corrections. And understand they have the right to search your house, phone, car, your computer at any time. Mr. Jones, anything else?
No, Judge, I'll just need to report to me on Monday morning.
Okay, so, and you need to report Monday morning at 8 o'clock to see Mr. Jones
You're across all.
on the 3rd floor at the probation. We'll have you sign your terms of probation and everything. Now, my bailiff is going to bring down to you 3 copies of your notice of right to appellate review on each of these files. You're going to sign the top copy for our records. You'll initial and date it just to acknowledge that you received it. The other copies are for your records. If you wish to appeal your sentence, you will fill out the information on the form and mail it to the address listed on the form within 42 days. Mr. Burke, thank you.
Got it. Thank you very much.
Thank you, Your Honor.
Thank you.
Mr. Malaro, thank you.
Thank you, Ms. Burke.
Thank you, Mr. Jones.
You
as
too,
well.
Mr. Jones.
Ms. Adams, were you able to reach Ms. Hennigan?
I did not get through on the phone and I emailed and I have not got a response back.
Thank you, Judge.
Thank you.
Your Honor.
Morning, Mr. Shadler. I'll be right with you.
It's been an IT kind of day.
All right, hold on, Mr. Shadler. I'm doing something right now. I'll be right with you. Your client's here, so I'll bring him in just a minute. Ms. Hennigan? We have a sentencing this morning. Camilo Pascal is here. Okay, thank you. All right, so Mr. Shadlin will bring your client in. I don't know this person. Good morning, Mr. Russell. Give me just a moment. Okay.
Yes, Your Honor.
Miss Adams, Mr. Orozco has zoomed in. So, Mr. Orozco, can you hear me?
Yes, ma'am. Yes, ma'am, Your Honor.
All right, Miss Adams, Mr. Orozco is marked off on my docket. Is it been adjourned?
He was adjourned to April 13th.
All right, so in the matter of the people of the state of Michigan versus Joel Jesus Orozco, we have two files, 2021-20645 FH and 2022-21150 FH. Mr. Orozco, your sentencing's been adjourned to April 13th at 8:15, okay?
All right.
All right, so you have a good day. And we'll see you back on that day.
Is it going to be over Zoom too?
Yes. You want it to be via Zoom or you want to be in person?
Zoom, if that's all right.
Okay, we'll be back via Zoom, okay? Thank you.
All right, have a good night. Have a good day. Thank you.
You too. Bye-bye. All right, in the matter of people of the state of Michigan versus Kyer Teron Russell, file number 2020-20089 FH. I have Philip Shadler appearing on behalf of Mr. Russell. Mr. Shadler, what is your P number, please?
Good morning, Your Honor. P35047.
All right, and Mr. Russell, you can hear me?
Yes, ma'am, Your Honor.
All right, Mr. Russell, have you had an opportunity to read and review the pre-sentence report?
Yes, ma'am, I have, Your Honor.
Good. Have you had an opportunity to discuss the pre-sentence report with Mr. Shadler?
Yes, ma'am.
Are you satisfied with Mr. Shadler as your attorney and the advice that he has given you?
Yes, ma'am, Your Honor.
All right. Mr. Shadler, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Your Honor, just briefly, Mr. Jones and I have had a chance to discuss some concerns that Mr. Russell had regarding drug use history. Firstly, that Mr. Russell stopped using any sort of drugs some 3 years before he began driving truck. And secondly, there's a reference to Mr. Russell's father's drug use history, which ended approximately 40 years ago. And that wouldn't be obvious from reading the pre-sentence investigation. But as Mr. Jones pointed out, neither of those issues is material to the recommendation.
Okay. Mr. Jones?
Yeah, I think in our conversation, I mean, I put that in there because that's was stated during the interview. So it's not false information. It's information that was provided to me at the interview. So I don't know that it's a huge change that needs to be made, but if the court wants me to make a change, I will. But it's information that was provided to me during the interview with Mr. Russell, who was totally cooperative with me. So
All right, very good. All right, anything else, Mr. Schindler?
Only, Your
On
Honor,
that.
that, I'm sorry?
With regard to.
No,
the
no,
accuracy.
I understand what Mr. Jones is saying and I understand the interpretation, and as I said before, and he said, those changes aren't material to the recommendation.
All right, so Mr. Shaler, just back up a little bit. So this plea, a judgment of guilt was entered, but it was under a delayed sentence. So at this point, he would be supervised by Mr. Jones for a period of 12 months. Is that
That's our
correct?
understanding, Your Honor.
Okay, and then if he's successful, you would work with prosecutor for whatever that might be. So Mr. Jones, this was a delayed plea. So would you be monitoring him or would it be Mr. Coast? Because the judgment of guilt was entered and we sentenced. And it is a probation term instead of the 3 years.
well, it would have to be 5 for the CSC charge. All CSC charges are 5. I was under the impression this was a review. I guess I'm not really clear on the delayed sentence. I was under the impression that the delayed sentence, we wouldn't have jurisdiction over him because you wanted to see how he would do for a period of 12 months. And if that's the case, then Mr. Coast would be supervising him until that 12 months is up. If he needs to be put on probation, then we would take.
Okay, that's what I was thinking. That's why I brought it up. Okay. So,
That's consistent with our understanding, Your Honor.
yeah. All right, so, Mr. Stabler, that information is all correct in the report then, and then is there, nothing else you want to dispute? So, is there any, does the pre-sentence report disclose any prior convictions? I don't show any. I don't show that he has any prior felonies, any prior misdemeanors, or a juvenile record. Do you
No,
agree with that,
that's
Mr. Stabler?
Yes.
The probation.
Your Honor,
All right,
that is
the
correct.
Okay, the probation department computed the minimum sentencing guidelines to be 0 to 6 months. Do you agree with that computation of guidelines?
Yes, Your Honor.
All right, so at this point, under the delayed sentence, we would set this out for 12 months. And Mr. Coast will supervise him during that 12 months. And I'm going to order that during that 12 months, he will pay, it's down. He will pay 700. All right, he will pay $750 in court costs. And you're retained in this matter, right?
Yes, Your Honor.
And he will pay. Let's see what it says. All right, so $750 in court costs, $130 crime victim rights fee. $68 in state costs. $60 DNA fee. And there will be a $30 per month supervision fee with Mr. Coast. So Mr. Coast, we're here on Mr. Russell.
Yes, ma'am.
And it's a delayed sentence, so you'll have to supervise him for 12 months just to make sure he complied.
Sure.
I ordered $750 at court costs to be paid, $130 crime victim right, $68 in state costs, $60 DNA fee, and $30 supervision fee. If you want to zoom in, I can put you in a breakout room with them.
I'll do that. Thank you.
Okay. So, Mr. Russell, we'll get him to zoom in here real quick. So.
Yes, Your Honor.
to his office right now.
Thank you.
And there he is. Okay.
Morning, Mr. Coast.
Hey, good morning, Phil. How are you?
Good.
All right. So, Mr. Russell, I've addressed the fines and costs. Your probation will be with our pretrial services coordinator, Mr. Coast, who I'll give you a breakout room in just a minute with. During that 12 months of delayed probation and supervision with Mr. Coast, let's see, is there, Mr. Jones, is he, until the 12 months is up, he doesn't have to register under SORA, correct?
That's correct.
Okay, so, Mr. Russo, during that 12 months, I'm gonna ask that, or order that you're not to, which I doubt you would, because you're a truck driver, not to use any illegal controlled substances or commit any crimes. And, other than that, Mr. Post, I'm not gonna order anything other than the fines and costs. And I
Okay.
know I think he drives over the road, so I'm fine with him not having to report in person at all times unless you need him to.
Sounds good, Judge. Thank you.
All right, so I'm going to set sentencing out to March, let's go March 16 of 2024 at
Judge,
8:15. Yes.
it looks like that's a Saturday on my calendar. Maybe the
2024?
15th? Yeah.
Oh, it's a 15, you're right. March 15 of 2024 at 8:15 in the morning. And that can be via Zoom, like we are today, that's fine. And Mr. Russell, I'm gonna put you in a breakout room with Mr. Coast, and he'll just explain how to reach him and what you need to do. And obviously, if you violate in any way, we'll have you brought back sooner, okay?
Yes, ma'am, Your Honor.
All right, so I'm going to open a breakout room with Mr. Russell and Mr. Coast. And Mr. Russell or Mr. Shaler, do you wish to join the breakout room too?
Yes, please. And I'd like to clarify just a couple things before we go off the record with you.
Okay,
Mr. Coast has two children Mr. Russell has two children and two stepchildren. Obviously,
I didn't order those terms, Mr. Shaler.
I'm sorry.
Are you talking about his bond conditions? I didn't order any terms regarding his children.
Okay, we'll leave it at that then.
Okay, all right.
And just so Mr. Russell understands, and maybe Mr. Coast is gonna clarify this for him. If he complies with the terms of his 12 months supervision, he would have the opportunity to ask the prosecuting attorney to dismiss this charge. Is that correct?
That's the agreement I believe you entered into, so.
Yeah.
All right, go ahead and join that breakout room.
Will do. Thank you, Your Honor.
All right, thank you all. And when you're all done, Mr. Russell, you can go on your way. All right, Ms. Reinhold,
Yes.
I'm gonna swear you in now, just so that when we start the case, you're good to go, okay? Can you raise your right hand? Do you solemnly swear or affirm that you will truly, accurately, and impartially interpret in the matter now before the court and not divulge confidential communications?
I do.
All right, and ma'am, for the benefit of my court reporter, can you state your full name for the record and spell your last name?
Gloria Reinhold, REINHOLD.
All right, thank you, ma'am. You can put your hand down, and I have the jail, but I don't know who's in that because it's not opened yet.
Judge, they are getting Mr. Pasquale right now.
Right, I will take these back and I'll be right back. Jeff, if you need to use the restroom real quick, go ahead. Right. Waiting for the jail. I'm gonna make Becky co-host. I'll be back. Check it. Jeff, I don't need you to wait for me over here.
Well,
when there's nobody in the
okay,
courtroom.
all right.
You're fine. You don't have to get back up and down with me. I'm just waiting for the jail.
Guess you got good sleep last night. I'm still tired.
Yeah.
Unbelievable. Coffee. You get your coffee?
Yeah, I do. Thank you.
I'm here for a settlement conference. Is everybody here? I haven't seen opposing counsel. It's in. Oh, the case number. No. All right.
I think I have your other attorney. If you want to do the pretrial. Maybe. Let me see.
Maggie Bull.
Well, I have Hicks. Attorney Hicks. Is he on yours? No. No, no, okay. No. So, right, it's only 9:03, so we're just waiting on Bradley Harris and Alexander.
Yeah, I'm not sure which one is gonna, I'm sure it's not gonna be Mr. Harris.
Okay, well, they're not here yet, so.
And I didn't see it in the hallways.
Okay.
I'll be.
All right, I have Miss Hennigan. I have Mr. Pasquale, so. Miss Reinhold, if you want to, this is, hold on, let me get this one. All right, this is in the matter of the people of the state of Michigan versus Camilo Hilario Pasquale. file number 2023-21208FC.
Mire, este es el caso del estado de Michigan en contra del señor Camilo Hilario Pascual, caso número 23-21208 FC. Yes.
Ms. Hennigan?
Yes, Your Honor.
All right, I have Tamaris Hennigan. What's your P number, Ms. Hennigan?
P 81968.
Appearing on behalf of Mr. Pascual.
Yes, Your Honor.
Aquí está la licenciada Tamaris Hennigan, número PH 1967, que comparece en nombre del señor Pascual. Así es, su señoría.
This is the date and time scheduled for sentencing in this matter.
Fecha y hora programada para la sentencia en este caso.
Mr. Pascual, have you had an opportunity to read and review the pre-sentence report?
Señor Pascual, ¿usted tuvo la oportunidad de leer y revisar el reporte previo a la sentencia?
No, solo
No.
vinieron y hasta hablar conmigo y solo yo respondí lo que ellos preguntaron.
No, they just came here to talk to me and then I just answered the questions they had for me.
So Ms. Hennigan, you've not reviewed the PSI yet with him?
¿Usted, señora Hennigan, no revisó el informe previo a sentencia con él?
We have not had an interpreter to go over to the jail to go over it with him, Your Honor.
No, no hubo
So,
intérprete en la cárcel para poder revisarlo con él, su señoría. Ajá.
Okay, so would you like a breakout room to do that?
Yes, if the interpreter can be placed in the breakout room with us. Yes, Your Honor. Thank you.
All right, so Ms. Reinhold, Ms. Hennigan, and Mr. Pascual, I will put you all into a breakout room.
Se lo van a llevar a una oficinita virtual al señor Pascual.
You have to join the breakout room. Ms. Adams, will you tell the jail to join the breakout room?
Okay.
Ms. Reinhold and Ms. Hennigan, we're waiting for the jail to click on join the breakout room for him. Ms. Adams,
Yes.
on Eckert versus Worley, are you able to find I know they did a stipulated order adjourning the scheduling order, but can you print off for me a copy of my last scheduling order that I signed? I didn't know if they were supposed to be here in person or via Zoom.
Okay, sure.
Your Honor, I'm here on that matter.
Right, Yep, I saw you guys. I just didn't know if we were supposed to be in person or Zoom.
I called your office earlier this week with that question, and I think the consensus was Zoom.
Okay. So I have you and I have Mr. Hicks. And I don't have anyone for plaintiff. So.
Your Honor, I'm here for the defendant, Jack Stowe.
Yep, I know. I haven't called the case yet,
Okay.
but I don't have a plaintiff's attorney yet.
All
So
right.
never mind, Ms. Adams. Mr. Daly, are you ready
Yes,
to
sure.
proceed on your case?
Yes.
And who do you have, Mr. Daly?
Timothy Greenwald.
Hold on a second. Close this breakout room, see if I can do that. Let's try and hold back. Ms. Reinhold, so Mr. Pasquale doesn't know to use the mouse to click to join, and I've called for someone to come help him join the breakout room. I don't know if you can instruct him to do that, or if
Okay.
you would know how to do that.
Mire, señor Pascual, ahí en la pantalla le sale un cuadrito que dice azul, que dice, usted no sabe leer, me dijeron, pero el cuadrito azul usted lo aprieta. ¿Usted sabe usar el mouse de la computadora?
No, no lo sé usar.
No.
Or he can go knock on the door to get someone to come in.
Toque la ventana, el vidrio, la puerta, para que alguien venga a ayudarlo, porque le tienen que dar un botoncito para que usted se pueda unir a la reunión. Tóquele a alguien para que venga un oficial, por favor.
Ahí viene.
Ok, gracias.
Okay, there you go. Now you can all go back to the Zoom room.
Entonces, nos vemos
Breakout
pronto.
room. Mr. Daly, let me grab your client's file. Okay, so this is in the matter of the people of the state of Michigan versus Timothy Allen Greenwald, file number 2022-21156FH. I have James Daly appearing on behalf of Mr. Greenwald. Mr. Daly, what is your P number, please?
25170.
All right, and Mr. Greenwald is present. Both parties are present in the courtroom. So let me write that down. All right, this is a date and time set for sentencing. Mr. Greenwald, have you had an opportunity to read and review the pre-sentence report?
Yes, I have.
And you've had an opportunity to discuss that pre-sentence report with your attorney?
Just momentarily with my attorney, yes.
Okay, well, you guys have been out in the hallway for a long time. Have you had enough time to discuss it with them, or do you need more time? Are you sure?
Yes, ma'am.
Okay, because if you need more time, I'll give you more time.
I think we're all right. The only thing that needs to be changed is I got a new phone number after.
Okay, well, hold on, we'll get to
We'll
that.
get to that.
Okay,
That's just it.
so Mr. Greenwald, are you satisfied with Mr. Daly as your attorney and the advice that he has given you?
Yes, Your Honor.
All right. All right, Mr. Daly, other than the phone number, which I don't want placed on the record.
Right.
Do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence?
No, Your Honor.
All right. Does the pre-sentence report disclose any prior convictions of which there exists any known constitutional defect? He has 4 prior felonies and 1 prior misdemeanor.
No, Your Honor, I'm not aware of any constitutional effects. All I would indicate is the judicial process in the Navy is different, and I'm not familiar with that process itself.
Okay.
But I'm sure it's following from what I see.
Okay, all right. Probation department has, I don't have a I don't have a guideline sheet for some reason on this file, but I show that the probation department computed the minimum sentencing guidelines to be 5 to 23 months. Do you agree with that computation of guidelines?
I do.
Mr. Jones, for some reason, I don't have an attached guideline. Okay, thank you. All right, so, Mr. Daly, before the court passes sentence, is there anything you'd like to say on behalf of Mr. Greenwald?
Yes, Your Honor. Under most circumstances, you could say that what happened to Mr. Greenwald was just the case of a senior citizen becoming angry and losing his temper and engaging in activities that were inappropriate. But Mr. Greenwald has went beyond that stage with his prior record. Because of his prior record, we have to address that as we address this now. And his prior record has demonstrated at times an inability to conform his behavior. This is an example of what that happened. The other side of it is he didn't really threaten anybody. It's not like he was trying to do anything except express his anger. He shouldn't have done it. It's inexcusable. And we're here because of it. And the one that's paying a significant price for all of this is the defendant in this matter. But, and keeping all of that in mind, I'm not so sure that adding to this defendant's problems with an additional period of incarceration is going to change anything for anybody. Anything else, Dad?
Okay. Mr. Greenwald, is there anything you'd like to say on your own behalf? Mr. Greenwald, can you go stand in front of the microphone because you're pretty soft spoken and we need to be able to hear you. So Mr. Daly will move over. Yeah, and you just talk into that microphone, all right?
I am a trained military officer who enforced the law. I was careful not to endanger anyone in any way, shape, or form. The beat and plead normally in the military is you're guilty until proven innocent, and there's no way that you're going to ever get out of their hate. I know this, I've seen it too many times. Even if for such little things as being in a bar across the way, when someone else starts a fight, you get busted in this case for those things. I was, after being attempted rammed by the so-called victim with her vehicle, I went to try to do a prayer. We call it spells. Trying to heal. And of course, $200, $300 on a tether because of somebody's, I want to get back at it. I was taught as a child, when you point fingers, you point with the whole hand. Because 2 fingers point, you did this, but 3 are coming back. No one ever saw that. Mr. Seymour, he's also involved in this perjury, as well as the so-called victim, and Mr. Paris.
I'm going to withdraw your plea, because that's what you're trying to tell the judge.
I would like, Your Honor, that this be noted in future from Mr. Paris and others. I am aware that right now that the state is looking at court costs. I'm also aware that in Ohio, for those interfering with religion, that they are facing up to 10 years by the U.S. Attorney's Office.
What religion? What are you talking about religion?
Last week before last, Ohio on the TV, that person was interfered with religion. And that the person involved was facing that.
And where was this?
You know, it was in Ohio, it was on the news.
Well, we all know about Ohio, don't we?
Yeah. I says Ohio is Ohio. I want to understand that I had no intention to harm these people. He says, I says, there's no way you're gonna stand against a 3,500-pound car. I says, with a 3-pound sword. I was attempting to draw a circle of protection. When somebody hit the horn, then I realized not everybody in this world knows what the hell I'm doing. So I retreated. Left them to their own hate. I do the best I can. My health is poor. I've had an open wound on my leg for over 5 years from diabetes. I work continuously overnight to do my best to make sure everything is done the best I can within the bounds of the law. I've been victimized by others. And I asked this in the past. And I also gave them leniency and understanding. I want to request the same. I would like to have my tether removed so I can actually go on again without interference, my worship.
Good. Anything else?
I don't know if I'm going to be around by the time this thing is done, as far as probation. I may not live that long. I have heart problems and things like that I must deal with too. I'm trying to live so I can get to see my grandchildren graduate high school. That's at least 15 years. I don't know if I'll make it.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. So I appreciate your concern about punishment for practicing your religion, but you have the right to practice whatever religion you want. And this court believes that people should have that freedom. But when you get in a car accident and you bring a sword out, another person might find that intimidating and threatening and assaultive. So doing a protective, you could use salt next time if you wanted, but a protective circle with a sword in public where someone was in an accident could be deemed threatening. Do you understand that? I mean, it kind of makes sense, right?
Yes.
So, just think about things like that so you don't get in trouble. So it's the sentence of the court that you will be placed on probation for a period of 2 years. You're gonna pay $750 in court costs, $130 crime victim rights fee, $68 in state costs, $60 DNA fee. There's a $30 per month supervision fee and $60 per month if electronic tether is required. I'm going to defer any jail time, so I'm not going to make you go to jail today. So I will defer the 150 days jail to the end of probation. So if you don't violate your probation, then there won't be any jail, okay? You're to have no contact with the victim named in this case. I'm gonna strike 1, Mr. Jones, and 2. You are not to use any illegal controlled substances. And take all medication as prescribed by your physician. And then during that term of probation, you can't possess any weapons, right? And that's a law under the state of Michigan. I don't have any control over that. So the sword would be deemed a weapon, so you'll have to find alternates, but you can't possess or use any object as a weapon under your terms of probation. And for probation supervision, the probation department can search your house, your vehicle, your computer, if they are concerned that there's a violation. Now, you do have the right to appeal this sentence. So my bailiff's going to bring down to you your notice of right to appellate review. I need you to sign 1 copy for my records. Just acknowledge that you received the paperwork. The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Now, I know the last time we were here, I told you a bond condition was you can't cast spells on people without their permission. Obviously, your bond conditions are listed, but be wise, and so you don't intimidate people when you do that, all right?
I will go back to the old prayer circle.
All right, very good. Thank you,
Because
sir.
that's what I have had I done that in the first place, we wouldn't be.
All right, Mr. Jones, any instructions for him?
Monday at 8:30.
So, Mr. Greenwald,
Yes,
Mr. Jones is gonna need you to come up here Monday at 8:30 in the morning to meet with him, okay?
What time do you gotta work?
anywhere from 8:30 to 11:30 in the morning, because because I work at Buddy's BP, I have shipments coming in.
Okay.
And I have no control over what comes
Do
in.
you
I'll
want me
come
to
in
make
as soon as I can.
Why don't you just go
Just give me a call when you get out of work, Mr. Greenwald.
Okay.
I just need to see you on Monday.
All right, so when you get out of work Monday, give him a call, okay?
And the tether?
You're not wearing it.
Yes, I am. This is the charge to buy.
Oh, okay, so yeah, you don't, that'll get removed today.
That would be through Mr. Coast.
So, Miss, why don't you have a seat in the hall and we'll have Mr. Coast come talk to you.
Okay.
Okay, Miss Adams, could you let Mr. Coast know that Mr. Greenwald will be in the hallway with his tether?
Okay, also Judge, before Mr. Daly leaves, I am being told that he has a special PD on Arturo Kuhn. The pickup.
Oh, okay.
Is that in this court?
Yes. Could I get paperwork for a copy of the paperwork from Mr. Daly?
Okay.
Is it just a contempt of court? Okay, okay, all right, so go have a seat in the hallway and Mr. Coast will come deal with your tether, all right?
Okay, I just want to make sure.
So, Mr. Daly,
Want to put you behind the 8 ball or me behind the 8 ball.
so you can, do you have other stuff at the courthouse?
I've got a hearing downstairs, a sentencing downstairs.
Okay, Mr. Kuhn was picked up on a contempt of court for failure to appear for a contempt of court hearing on March 6th. And so he's at the jail. What time's your hearing downstairs?
That won't take long. I'm supposed to go to Ann Arbor after that.
Okay, Miss Adams, is the jail able to zoom Mr. Kuhn in from the first floor?
I will check.
Let me see if I can take care of it right now. All right.
Your Honor, just as a heads up, I think we may need a prosecutor, Mr. Pascal, so that the prosecutor and I could speak with you.
I don't have time to do that today. Are you objecting to guidelines or something?
Yes.
Okay, so I don't do that on the record. You have to file a sentencing memorandum or talk to the prosecutor and see if they agree. So let me call the case and we'll adjourn it. This is back on the record in the matter of the people of the state of Michigan versus Camilo Hilario Pascual.
Mire, el caso de el estado de Michigan en contra de Camilo Hilario Pascual.
Mr. Pascual, your attorney has some objections to the sentencing guidelines.
Mire, señor Pascual, su abogado tiene varias objeciones a las pautas que se han utilizado para su sentencia.
Because you are facing a prison term.
Sí, como usted está enfrentando a tiempo en prisión.
For purposes of appeals, I do require those sentencing memorandums to be in written form.
Para fines de apelación, yo necesito que eso se presente en forma de memorando.
Your attorney wishes to discuss it with the prosecutor.
Su abogado tiene que conversar eso con el abogado fiscal.
So I will adjourn this.
Sí. Entonces, esta audiencia la vamos a aplazar.
Ms. Adams, I'm looking, is April 28th the date we were using?
Sería 28 de abril.
Yes, it is, Judge.
Así es.
All right. So I'm going to adjourn sentencing to April 28th at 8:15 via Zoom.
Entonces, se aplaza la audiencia para fines de sentencia para el 28 de abril a las 8:15 de la mañana y otra vez por vía Zoom.
Ms. Hennigan, unless you reach an agreement with the prosecutor, your sentencing memorandum will be due March 31st.
Mire, a menos que usted llegue a un acuerdo, licenciada Hennigan, con la fiscal, entonces el memorando de usted lo tiene que entregar para, and I'm sorry, Your Honor, what's the date? March?
March 31.
Para el 31 de marzo, a más tardar, tiene que usted presentar su memorando.
The people's response will be due by April 14.
Y la respuesta de la fiscalía se debe entregar a más tardar el 14 de abril.
And any rebuttal response by the defendant by the 21st.
Cualquier refutación a más tardar para el 21.
Mr. Pascual, do you have any objection to appearing via Zoom for that sentencing day?
¿Usted tiene alguna oposición? Se opone a que ese día usted se presente otra vez por Zoom.
¿Cómo de qué?
¿Usted tiene alguna objeción? ¿Usted se opone a que la próxima audiencia sea por Zoom de nuevo?
Sí.
Mr. Pascual, do you want to appear via Zoom or in person?
Mire, usted quisiera presentarse en la corte en persona, presencialmente o por Zoom, como se hizo ahora.
Como se hizo ahora.
Just like we did today.
Okay,
Yes.
Zoom, okay. All right, we will see you back on that day. Thank you.
Nos vemos ese día entonces, gracias. Okay.
All right, you're all set. Thank you, Ms. Reinhold and Ms. Hennigan.
Thank you, Your Honor.
All right, Mr. Daly, it looks like I got a jail window. Let's see who I'm getting. 7 gentlemen just walked in. Mr. Kuhn, is that you?
It is.
All right. This is in the matter of the people of the state of Michigan versus Arturo Kuhn, file number 2022-21197FH. Mr. Kuhn, we are here on two contempts, actually. I have a contempt of court and a motion in order to show cause, which alleged that you violated the terms of your probation by failing to drug screen on February 1 of 2022, February 9 of 2023, and February 13 of 2023, as directed as a bond condition. I also have another contempt of court alleging that you failed to appear for that contempt hearing that was scheduled on March 6 of 2023 for bond violations. So, Mr. Kuhn, we have two contempt of courts. Now you do have a right to have an attorney represent you on the contempt of courts. And I know that we have Mr. Daly appointed as your special public defender. Do you want him to represent you on the contempt of courts?
Oh, no, it's all right. It's pretty cut and dry. I understand. I was supposed to be there and I didn't arrive.
Okay, hold on. So Mr. Kuhn, it's not, it can be cut and dry, but I do have Mr. Daly here. So do you wish to proceed with the contempt of courts, or do you want me, when's the next pretrial on this, Ms. Adams? I'm looking. Looks like.
Check.
All right, so he's set for sentencing. Did he appear for sentencing?
No.
No? All right.
Nope.
So Mr. Kuhn, you were originally scheduled for sentencing on March 3rd of 2023. Let me ask you a question. Did you go meet with the probation department and fill out the packet and have a meeting with them?
I didn't arrive on time. That day when I went to court, what was it? I think it was the 28th or the 23rd. Around, anyways, I was out of state at the moment, helping my mother. She had just gotten surgery. I told them that I was
so
trying
let
to
me
get back
ask you
in
my
town. I
question,
didn't make it.
Mr. Kuhn, hold on. Did you have a meeting with the probation department
No.
to go
No, I
over
did not.
PSI? Okay, so Mr. Daly, I need, because I don't have a pre-sentence report and he failed to appear for that sentencing. Mr. Kuhn, I'm gonna set this for sentencing on April 28th at 8:15 in the morning. And Mr. Kuhn and Mr. Daly, so Mr. Kuhn, when you fail to appear for your pre-sentence report or process it, you know, that bench warrant's been issued. I'm gonna revoke your bond and set it for sentencing on April 28th at 8:15 in the morning. Because you had a PR bond, I believe, or did you post bond? Let me see here.
PR bond.
You had a PR bond. So I'm gonna revoke your PR bond and set bond in the amount of 25,000 cash as surety. And then, let me see here, what's your bond on contempt of court? Let's see. And then I'm going to set the bond on the contempt of court. It's already set at 50,000, so I'm gonna leave that. And Mr. Daly, do you want me to set the contempt of courts over with the sentencing?
Yes.
All right, Mr. Kuhn, we'll see you back here April 28th at 8:15 for sentencing. The probation department's gonna come meet with you, be truthful with them about your background, the events that occurred, and then Mr. Daly will review the pre-sentence report with you. We'll see you back on that day. Anything else, Mr. Daly?
Oh, yeah.
All right, Mr. Kuhn, do you wish to appear for sentencing in person, or do you want to appear via Zoom?
I'd appear in person. From it being jail,
Okay.
I'd rather go.
All right, so we'll set that sentencing in person. All right, thank you, Mr. Kuhn, you're all set.
Thank you, Judge.
All right, thank you, Mr. Daly. All right, so Ms. Adams, whoever they can bring me. Okay. So it looks like we have a bunch of attorneys. All right, so I'm gonna take the attorneys that were present here in person. I don't have all of them, but I have two, right?
That's all that's left.
Okay, all right, this is in the matter of James Nagy-Pell and Lisa Weddle versus Dennis Howard Bordner, Christine Marie Gross, and Richard Harry Gross, jointly and severally, file number 2022-6864 NI. I have Keith A. Schroeder, P42303, appearing on behalf of defendants Gross.
Morning, Your Honor. Andrew Franklin, P76139, on behalf of the plaintiffs.
On behalf of the plaintiff. All right, so this is the date and time. Looks like for a final settlement conference, is that correct?
That's correct.
All right, and where do the parties stand at this time?
We're looking to get a trial date.
Okay, so. All right, so this is a civil case, and I've probably gone through this spiel with you before. So we are still working our way through our criminal trials that have been delayed by the pandemic, although for all intents and purposes, the pandemic's over and we're just moving through these trials. Most of them plead out, but I schedule 5 to 7 criminal trials a week, and usually I don't have one at all. But it still bogs up my docket, and I know that in civil cases, you have a lot of expert witnesses and professionals that probably don't appreciate being told to appear and canceling a million times. So how long do you feel you need for trial on this?
I think the trial would probably be 2 to 3 days. I agree with that assessment.
All right, Ms. Adams, I'm looking for a trial date, October, maybe November, 3 days.
Oh,
This is jury trial.
did you say 3 days, Judge?
Yes, ma'am.
October 10th, it's a Tuesday.
October 10th.
That works on my calendar, Your Honor. It works for me, Your Honor.
All right, and okay, so that's a Tuesday. Trials start at 9 a.m. every day except for Wednesday. We have a start time of 10:30 on Wednesdays because my criminal docket is in the morning. It's my arraignment docket. Discovery's been completed. Witness lists have been provided and exchanged.
Yes, Your Honor.
Motions have been filed. So at this point, I don't think there's anything else. Now, each party, I would prefer if you guys meet and submit a fully complete set of jury instructions in a book form, a verdict form that you've agreed on. If you can't agree on some of the jury instructions, obviously we can address it the morning of. Or the verdict form, and then I handle voir dire. But I would ask that you submit any case-specific voir dire questions. We'll review them, I'll ask them, but I do allow you to follow up questions. And those are all due to the court at least 5 business days prior to trial. Each requested instruction must be set forth, and I'm going to get you a copy of this too, in full, completed, and on a separate page. Each one must be on its own page. To timely file constitutes a waiver of jury trial by the party not timely filing. All depositions must be completed 21 days prior to trial. The court reporter must be provided a list of marked exhibits at least 2 business days prior to trial. Let's see. Is there anything you wish to address today?
Not for me.
So, Ms. Adams, if we could get a copy of this for councils. So who's been, Howard Wardner has been dismissed, so it's just Gross, right?
Correct, Your Honor.
Ms. Kramer? Will you let the jail know your hearing's not until 11 o'clock?
I did tell him, but he said it was my turn. Okay, I'll let him know.
Okay, thank you.
Not a problem. Not gonna love it.
And sir, just for my notes, can I have your full name again and your P number?
Yeah, Andrew Franklin, 76139.
76139.
Yes.
No, not yet. Hold on.
All right, so we got a copy of that scheduling order for you gentlemen, and we will see you back.
Thank you, Ryan.
Thank you.
Okay.
Thank you. So, Mr. Hicks. And Mr. Gallagher and I don't want to slaughter your name, Rula Aoun.
Good morning. It's a fine job. Thank you.
Did I do it? Yes.
Last name is Own, but the U is in there, so my parents should blame
Own,
themselves.
so it's Own, right? Own. All right. I am so sorry. Okay, this is in the matter of Tracy Lee Eckert versus Cameron James Worley, Rhonda Sue Howard, and Jack Henry Stewie, file number 2021-6813 NI. I have Rula Own, case 79119, appearing on behalf of the plaintiff. I have I have James M. Hicks, P42699, appearing on behalf of defendants. Is it Stewie or Stu?
Stewie is fine, Your Honor.
Okay. And then Mr. Gallagher, you're appearing on behalf of defendants Worley and Howard, correct?
Right, correct, Your Honor. P80013.
Okay, Brian Gallagher. All right. So I do have that you did a stipend order to adjourn the final pretrial to today, or the settlement conference. Did you guys actually have a trial date on January 13th?
No, Your Honor. I believe when you adjourned our scheduling order, you gave us the state as kind of a placeholder. You didn't really give us a future trial date. So my assumption was we were going to get a trial date today.
Okay. Okay, because I'm looking. All right, so we haven't done a settlement conference in person yet, though, right?
Correct.
Correct, Your Honor.
Are you okay? You're angry though. I don't know, but just hear me out over an individual comes a certain way for years, all the time, whatever you see for the individual, a certain way. Every time you see them nice, whatever. Today's March 17. All right, so discovery was cut off in November, so discovery is complete, correct?
Correct.
Yes and no, Your Honor. We can discuss it further if you want.
Okay, go ahead.
Well, Judge, we were at facilitation a few days ago, and we learned at the facilitation that the plaintiff is planning on having a shoulder surgery. I don't know when the date was, so we really didn't have settlement discussions in earnest. And based on the fact that I don't know when this surgery is going to take place, it's kind of difficult to, I guess, predict what further discovery or follow-up discovery we'd need based on that shoulder surgery. So basically, that's kind of our issue. Is we're kind of in limbo here.
Ms. Ohm?
Yes. I don't have any additional information with regards to a date either, unfortunately.
Okay. Mr. Hicks?
I can't imagine
go
it's
ahead.
too though. So
No, go ahead, Ms. Ohm. You can imagine what?
that it's not too far out usually. I mean, it's surgery is not like a trial date. So
Well, I don't know. I almost think sometimes it depends. Mr. Hicks, your input?
Oh, I was just going to say, I think there was an MRI done, and I don't think we have the actual report yet, which is, I think, the basis for the surgery. Up until the point of the surgery aspect being brought up, I think it was a relatively moderate to minor injury, but that changed the dynamic, and I think that's why we couldn't really get anything done at the facilitation a few days ago. I don't know that this case isn't a case to be resolved, but I just think that because of that MRI and the potential of the surgery, although it sounds like he's going to have surgery, that kind of added dynamic that the parties weren't really ready for at the facilitation.
Okay, so, all right. So what I'm gonna do is set a settlement conference in person, all parties with all attorneys plus all parties and for defense counsel and plaintiff with settlement authority must appear, and I'm going to set it for July 7th at 9 a.m. Ms. Adams, is July 7th at 9 a.m.? Oh, yes.
sorry, I was going to say I'm out of the country for the first 2 weeks of July, and I know that I'm most likely going to be appearing for the conference. So if we can get a different time.
Ms. Adams, July 21st.
That's a good date.
Okay, July 21st, Mr. Hicks at 9
That's
a.m.
fine. That's fine, Your
Mr.
Honor.
Gallagher?
Thanks.
Yes, Your Honor.
All right, so I'm going to set this for a settlement conference on July 21st of 2023. That'll be at 9 a.m. All parties with settlement authority plus the attorneys must be present in person. Plan to spend the morning if we need to try to see if we can resolve it. And at that time, I expect all facilitation to have been done. And we'll see where we are, and I can set a trial date on that day if we need to. So anything else we want to address today?
Thank you, Your Honor.
No, Your Honor, thank you.
No,
All right,
thank you.
so I've done a scheduling order and my staff will get that out to you. All right.
Thank you, Judge.
Thank you
All
very
right,
much.
thank you both.
Good day.
Thank you all. Have a good day.
You too.
So Sir, hold on 1 minute and I'll be right with you. All right, so I have someone from the jail. Can I have your name, please?
John Berry.
Okay. This is in the matter of the people of the state of Michigan versus John Wilson Berry, B-E-R-R-Y. File number 2021-20370FH. Mr. Berry, we are here today on a motion, affidavit, and bench warrant. States here that you failed to appear for circuit court arraignment on June 9 of 2021. So, Mr. Berry, you were appointed a special public defender back then, Mr. Brian Fry. So you do have the right to have an attorney represent you here today in all subsequent contempt of court hearings. Contempt of court carries a maximum penalty of up to 93 days in jail and a $7,500 fine. Mr. Berry, would you like an attorney appointed to represent you on the contempt of court?
Yes, Your Honor.
All right, so Mr. Berry, we will appoint counsel to represent you. I'm not sure when I'll be able to get someone today, so just know that sometime today we will have you brought back with an attorney, all right?
Okay, thank you.
All right, you're welcome. Ms. Adams and Mr. Fry would be his attorney. All right, you're all set, sir.
Oh, 167.
George, did you need somebody else from downstairs?
Let me see here. I think, let's see, we did. I don't think so. I think we're good.
All right, thank you.
Thank you. Have a good day.
Tamika Hill, Judge.
Oh, wait. I'm sorry. I misspoke. There was a pickup I forgot about. Samika Hill.
Judge, we still do not have that warrant.
Yep, I'll get her right now.
All right, thank you.
Hill, can you wake her up, please?
Huh.
You know who has the warrant, Miss Adams?
Everybody's saying they don't have it, Judge.
Could you radio Justin? It's my understanding Justin brought the warrant over yesterday.
Go ahead and sit right there for a minute. Sorry, don't you're fine.
All right, Ms. Hill. All right, hold on 1 second, all right?
Someone's in route there right now.
Okay. All right, Ms. Adams, someone is en route with the paperwork for Ms. Hill right now.
Thank you very much.
Okay.
Could we send a message to Ms. Underwood as well?
Yeah, she said she was gonna be back in about 10 minutes.
Okay.
I was emailing Mr. Fry to see if he was available. Awesome.
Thank you. All right, so Ms. Hill, just bear with us for a moment, all right?
No problem. For return, there's somebody waiting for my paperwork.
All right. Okay, Ms. Hill, this is in the matter of the people of the state of Michigan versus Samika Irene Hill, file number 2020-20040FH. So Ms. Hill, we are here today on a contempt of court for failure to appear for sentencing on February 3rd of 2023. So Ms. Hill, a contempt of court carries a maximum penalty of up to 93 days in jail and a $7,500 fine. Do you understand that, Ms. Hill?
I do, but I was told that my court date was rescheduled. I received a letter.
So hold on, Ms. Hill. Ms. Hill, you are represented by Ms. Underwood, and Ms. Underwood is available this morning. So would you like Ms. Underwood appointed to represent you on the contempt of court and talk to you this morning?
Yes.
Okay, all right, so Ms. Hill, Ms. Underwood will just be a couple minutes, so just bear with us. When she gets here from the other court, we'll put you in a breakout room, all right?
Thank you.
All right, we're gonna go this way.
All right, good. Open up. Yeah, I'm going right now. Just say Attorney General. You still don't have? I'm waiting on my public defender.
Sergeant Keith, Officer Rutherford.
So,
Busy enough, I mean, what are they gonna do?
Court appeal.
But what are they doing?
John taking care of court appeal.
right, Ms. Hill, we're waiting for Ms. Underwood, so just be a minute.
Yeah.
Now, cause I gotta, I'm getting. Yeah, don't. Okay. Oh, yeah, that's fine. Does the magistrate know that?
Ms. Underwood? All right, so Ms. Underwood, this is in the matter of the people of the state of Michigan versus Samika Irene Hill, file number 2020-20040FH. So Ms. Underwood, Ms. Hill is present. We do have a contempt of court for failure to appear for sentencing on February 3rd of 2023. At the time of taking of the plea, we set sentencing for December 16th at 8:15 in the morning, and a notice was sent out for that day. And then Ms. Underwood, my understanding is she did not report at any time to probation as instructed or contact probation, so we do not have a pre-sentence report. I know that I specifically, against Ms. Walsh's wishes, did allow her to do it via Zoom, but we still had no compliance. So she does have the contempt of court for failure to appear, but as well. So Ms. Underwood, she requested court-appointed counsel on the contempt of court as well. So I'm going to assign you and Ms. Hill to a breakout room. There you go. Very good.